Twitter employees have just sued the corporation, accusing Elon Musk of unfair business practices. Workers at Twitter claim that Musk violated the federal and California WARN Acts and are suing the company collectively. However, Twitter provided information in court filings that offer compelling evidence to protect its interests. Musk is taking this lawsuit very seriously because it can have catastrophic results for the company. In addition, experts of the law came out and critiqued Elon Musk, saying that he was wrong about the specific action that he did. Moreover, Elon Musk stunned everyone when he came out and officially declared that he has already fired 75% of Twitter employees, and as Musk claims, now the platform works far better with the remaining 25% of total employees. But how did Elon Musk manage to do it? Well, Elon established a very smart system that drastically changed the whole platform, and now Twitter looks more exciting than ever. This is a very interesting story, so let's explain it. Elon has adopted several bold policies and reforms since assuming leadership of the firm, including collecting membership fees for authentication and firing around 4,000 people, approximately 75% of total workforce. Now, Elon Musk claimed on Twitter that, even after firing 75% of Twitter employees, the company now works even better. And now, Elon aims to further increase productivity and reduce salaries and wages because Twitter has employed an unusually large number of employees in the previous several years. Soon after, Twitter issued an ultimatum to staff, requiring them to be extremely hardcore and work long hours of high intensity or leave. As a result of the change, more employees left. Twitter has offices throughout the world, including one in California. The Federal Worker Adjustment and Retraining Notification Act and the California Worker Adjustment and Retraining Notification Act both govern how businesses manage major layoffs. Employees with more than 100 employees are required by federal law to offer at least 60 days' notice before mass layoffs. California's legislation offers similar safeguards. Employees of Twitter have filed a lawsuit, saying that the corporation breached these acts by failing to provide appropriate notice of the layoffs. Musk has faced similar lawsuits in the past, including when Tesla laid off thousands of employees in June of this year. Twitter told employees that they would continue to get salaries and benefits even if they had been let go, which it seems to believe meets the WARN Act requirements. Twitter workers say that the cutbacks breach both the federal and California WARN Acts, and they want to sue the corporation as a class action. Meanwhile, in a tweet, Musk claimed that the business provided 3 months of compensation, which is 50% more than legally necessary. The claim is expected to go to court, where a judge will make a decision. Twitter has had a turbulent year in the market, with shares dipping as low as $33 and peaking at $53.70. The company was delisted after Musk acquired it, which means it no longer traded on the public stock market. Because the firm is no longer publicly traded, investors do not need to be concerned with the performance or value of the company's shares. However, it's worth keeping an eye on the business and this court battle. Twitter's fate may have ramifications for other social media sites and technology companies. If Twitter fails, other sites may fill the void, giving an established platform a bigger portion of the market, or providing an opportunity for a newcomer to enjoy explosive growth. Whether Twitter survives this storm, investors may want to keep an eye on the firm to see if it goes public again. Meta, Facebook's parent company, has also announced layoffs. The social media behemoth is laying off 11,000 people, or 13% of its workforce. Meta has provided a substantial severance payment, but it is uncertain whether its employees would file a similar complaint against their former company. Investors in Meta and other social media sites may be watching how Twitter's lawsuit plays out. Twitter's turbulent year came to a close with Elon Musk's takeover of the company, huge layoffs, and lawsuits filed by former workers under federal worker protection statutes. While it is uncertain which side of the lawsuit will prevail, investors will undoubtedly keep a close eye on the case to determine if Twitter can survive its change in ownership and make significant adjustments to enhance profitability. Twitter has informed a federal judge in San Francisco that a lawsuit alleging the business violated US law by letting go thousands of employees without notice is unfounded, and has asked for the accusations to be resolved through arbitration. The court filings are Twitter's first reaction to the potential class action, which was filed under a federal statute that requires 60 days' notice before mass layoffs. Twitter stated that it had fulfilled its legal requirements by informing laid-off employees that their final day would be January the 4th, or more than 60 days later. The company claimed that a pending request by the plaintiffs to require Twitter to tell laid-off employees about the case before asking them to sign severance packages had simply generated uncertainty and delayed severance payments, and urged a court to dismiss it. In a second filing, Twitter stated that the plaintiffs had made arrangements to resolve employment-related problems, and requested that the claims be sent to individual arbitration. Arbitration helps businesses to avoid costly class action lawsuits, and business organizations claim that it is less expensive and much more efficient than going to court. If the case is tossed out of court, plaintiff's lawyer, Shannon Liss Riordan, says she is ready to represent workers in arbitration. Twitter's argument to the plaintiff's move, according to Liss Riordan, is simply that arbitration agreements bind the workers, thus Twitter doesn't have to worry about the law being broken. She claims that Twitter is wrong. There is minimal legal precedent on when remote working is a reasonable request under the ADA, and the answer ultimately depends on the facts of specific cases. As a result, bringing a disability bias claim in a class action lawsuit might be challenging. The United States Equal Employment Opportunity Commission, which administers the ADA, stated in 2020 advice that remote employment can be a reasonable accommodation where it does not impose an undue hardship on an employer. According to Michael Leroy, a professor of employment and labor relations at the University of Illinois, the combined lawsuits might cost Twitter millions of dollars. However, the legal processes might last more than 5 years, giving the corporation power if it pursues settlements with former employees, according to Leroy. Under federal labor law, corporations have the flexibility to fire employees without cause, a practice known as at-will employment. However, businesses face various limitations on the type or implementation of layoffs, such as anti-discrimination laws, and demands that employees at some firms be notified in advance of big layoffs. Liz Riordan said that she understands that business executives and owners have the authority to make decisions about how the firm should run in the future. But she noted that there are rules in place to safeguard workers and employees who are subject to layoffs. Nonetheless, Leroy believes the company might make claims based on exemptions in the relevant law. For example, the federal regulation requiring large businesses to offer some warning of mass layoffs excludes companies in financial distress, he noted. He believes this adds uncertainty to the situation. Furthermore, the legal procedures might drag out for years, providing Twitter an advantage while it defends the claims or seeks a favorable settlement, according to Leroy. Liz Riordan, the attorney in charge of some of the lawsuits against Twitter, acknowledged the difficulty of a potentially protracted judicial battle, but claimed the cases against Twitter may well be settled swiftly. That's it for today. Subscribe to our channel and hit the notification bell.